Hello, we're here today with Maureen McKee, who's running for Superior Court Judge, position number 5. Would you like to go ahead with your 2-minute introduction?
Thank you. Last August, I was appointed by Governor Inslee to the King County Superior Court bench, and as a new appointee, I'm required to run for election this year. I think and I believe that Governor Inslee would agree when he appointed me that I bring a unique perspective to the bench. For the past 25 years of my professional life, I've worked to serve the community, specifically marginalized communities. After graduating from college with a Black Studies major, I was a visitor volunteer, working closely with Latino immigrants in Chicago seeking naturalization. After that job, I went to New York City and worked with the National Institute for People with Developmental Disabilities, working with young adults striving to gain a foothold in the workforce. I then went to law school, and during law school I had opportunities including working in Bosnia after the conflict in former Yugoslavia, working with displaced persons, and then also with incarcerated females struggling to protect their parental rights. After graduating from law school, I came out to Washington State, to Seattle, for the job, and that job was to work at the Public Defender's Office, where I stayed for almost 16 years, right up to the time when I became a judge. The thing that inspired me to become a public defender is the very same reason why I decided to apply for appointment on the bench, and that is to ensure that the justice system is a place that's not there to serve a select few, but a justice system that is there to serve everyone equitably, regardless of race, gender, ethnicity, or religion. Thank you.
Thank you. And now we'll get into the questions. If you want to go ahead and flip that over, you can follow along. We are starting with Jeff.
How would you describe your judicial philosophy?
My judicial philosophy is to do two things, one on a micro level and one on a macro level. On a micro level, regarding what happens in my own courtroom, I strive to be thoughtful, to be compassionate, and to be fair. I think the term fair or fairness is used so ubiquitously that it's almost devoid of meaning at times. What I mean when I say fair is to strive to develop empathy for everyone who steps foot in my courtroom, including obviously litigants, regardless of where they're from, what their experiences are, and what their perspectives are, but also including jurors, witnesses, attorneys, and support staff. On a macro level, what I hope to do as a judge is to work closely with my colleagues on issues in the pursuit of equity. Examples of what I mean include work on bail reform, which most certainly has a strong impact on people of color and people who are indigent, and then also on issues such as jury diversification.
Thank you. Clayton?
In the area of hate crimes, what are some of the issues in balancing free speech rights against the need to control offensive activity?
I think that issues involving the First Amendment, and specifically freedom of speech, can be extremely complex. Consequently, there are so many cases on that issue, so many cases by the United States Supreme Court. The First Amendment was developed for the purpose of, number one, protecting speech, but behind that, the intent was to make sure that there was protection of wide discourse of ideas, thoughts, and positions. The First Amendment is one of the fundamental aspects of our democracy, and without the First Amendment, our democracy is undermined. The First Amendment doesn't only protect speech that we enjoy, or that we like, or that we agree with, but perhaps more importantly, arguably, it protects speech that we dislike, that we find offensive, that outrages us. Without that protection of that type of speech, speech that we are so outraged by, we don't have protection of the speech that we like. The First Amendment has some exceptions, but those exceptions are limited. They do not include hate speech. As recently as 2017, the United States Supreme Court said that hate speech is protected by the First Amendment. Finding that fine line between hate speech that is offensive, that we absolutely dislike, that is protected, versus speech that incites retaliation or violence is a very fine line, but it's a very important line that courts and law enforcement have to identify. An example might be Charlottesville, where people have the right to march. People we may have absolute disagreement with, people we may have strong dislike of, they have a right to march. What they don't have a right to do is incite retaliation, which is what we saw in Charlottesville.
Great, thank you. Maureen?
How would you or how do you deal with a pro se party here in New York?
Currently, I am in the rotation of Unified Family Court, which is simply family law cases involving minor children. I'm in the Regional Justice Center, which is located in Kent, Washington, and that position, my position, presides over many cases involving one pro se party or two pro se parties. And so I have, in the past 4.5 months, I have dealt a lot with pro se litigants. Previous to that, as a public defender, I also I crossed paths where I had dealings with pro se defendants. Although I obviously didn't represent them because they are not represented, sometimes they are assigned attorneys to be backup support. I've also been an investigator for a pro se litigant who was charged with 2 counts of premeditated murder or murder in the first degree. My approach or my philosophy is to ensure that pro se litigants have the support that they need, but that I don't overstep my boundary and become their advocate. It would be easy, especially given my background as an advocate, to want to help individuals, especially when they're in a vulnerable position, and pro se litigants are in a vulnerable position. But as a judge, I can't do that. That's not my role. What the Superior Court has done in order to try to even the playing field is provide support such as early resolution case managers, who are attorneys, who are there to support pro se litigants, guide them through the path, down the path of litigation without representing them, provide materials, help them fill out proposed orders, prepare trial binders, and by that moves us towards the goal of equity, which is what we want when we're dealing with pro se litigants, especially when they are opposed to litigants who are represented by attorneys.
Great, thank you. Laura?
Like the rest of government, the courts have struggled with reductions in funding. Where can the courts cut costs and increase efficiency, and how will you advocate for sufficient funding of our judicial branch?
I think that after I gained more experience in determining what systems work and what systems don't, I can be a better advocate and work more closely, effectively with my colleagues in identifying what would be an effective use of funding and what isn't an effective use of funding. An example that I just gave you, the early resolution case managers, is an extremely effective use of case management, of funding. One example which I did not give is early resolution case managers also mediate cases when there are 2 pro se parties. By mediating cases, they help resolve the cases. So what I've seen is, in my caseload, there is many of the cases I have regarding with 2 pro se parties resolved through settlement with the help of the early resolution case managers. That means those cases don't take up 1 day, 2 days, 3 days of my time in trial. And I could easily see, while I don't have a hard data, I could easily see that without funding for those early resolution case managers, we would need another judge. And I can assure you that judges cost a lot more than the early resolution case managers, including not just judges, but bailiffs, court staff, and all that comes with opening a courtroom. So that's an example of excellent use of funding. I would certainly do my best to learn more about the services that the Superior Court, not just in King County, but also services that are effectively used in other court systems, and try my very best to work closely with my colleagues to advocate for that funding. Because that not only serves the court, it also serves the litigants, and of course it serves taxpayers. Thank you.
And now we are opening it up to questions. So we'll start with Matt and Jason and Clayton.
So you spoke earlier about your experience working with adults with developmental disabilities. I wanted to see how that experience has impacted your decision making when you're working either with a parent, when we're not working with judging a case where there's a parent with a developmental disability or a child with a developmental disability.
Right. So I think that the biggest takeaway I had from that job, from the job I had at the National Institute for People with Developmental Disabilities, is the importance of empathy coupled with the importance of making sure that individual has a voice. So my approach as a judge, I have a litigant, a witness, a parent or a child of a litigant, is to try as best I can to understand their perspective, to understand how they can best be served by the court system, and how best they can exercise their voice within the confines of whatever litigation is taking place.
Thank you. Ben.
So we talked a little bit about hate speech. I'd like to go back to that. Flying the swastika flag, the Nazi flag, implies an agreement with the ideals that the Nazis represent, which is the extermination of an entire people. Should it be protected by free speech to fly that flag and advocate for the extermination of humans?
Right. I think that has been addressed by case law by the United States Supreme Court. It is, I think it's an extremely complex issue given the history that where it arises from, but I do believe that would fall under the category of protected speech unless it is accompanied by other acts in which arguably it could be used to incite retaliation or lawless action. So I think we can probably identify scenarios in which someone has flown a Nazi flag, but it wasn't coupled or combined with other behavior that would incite lawless action, and we can most certainly identify incidents in which it was coupled or combined with actions which most certainly was to incite lawless action or retaliation of some sort. If it's the latter, that would be prohibited. That would fall under the exception of what's protected under the First Amendment.
Thank you.
Thank you. We had Jason next.
Yes, in Florida, we had someone with developmental disability, autism, basketball, and which is exciting news.
Yeah.
How do you think we can best get more people like ourselves being lawyers, creating law firms, and being judges that have a disability, especially maybe a developmental disability?
Right. I think that, again, I think the overarching theme here is empathy. Striving to understand the experiences of a person with a certain disability and what that means in the context of getting into law school, engaging in law school, passing the bar, and then obtaining a job. And then also being in that position. So it's a whole continuum of possible obstacles that a person may face given the disability. And then working together as far as trying to promote or support the person in overcoming those obstacles, or better yet, removing those obstacles.
Thank you.
Thank you. Clayton.
You bring an extraordinarily rich background to any court. And so I wanted to follow up a little bit and inquire what your work in Sarajevo has meant for your work in the law.
Right. So I never went to Sarajevo. I was in Mostar, which is a little town. It's very good. Yeah, same area, right? Mostar. But I didn't want to mislead anyone. But certainly.
Bridge.
What was that?
It had a great bridge.
It had a great bridge. And the reconstruction had not started when I was there. I think what was most shocking to me in my experience, which was limited in Bosnia, but certainly impactful, was that the conflict that could arise out of a community which had so closely worked together. And historically, and I do not claim at all for 1 second to be an expert on the history of the former Yugoslavia, but what I do, my very strong impression from working there is that individuals who ultimately were in conflict with one another during the 5 years of the Yugoslavia conflict worked together, were friends, were neighbors, were collaborators, and that so much happened as far as, anyway, the government was extremely proactive in creating divisions that gave rise to what was a horrific conflict during those 5 years.
Thank you.
Thank you. Matt?
I just wanted to ask, when you were addressing my question, Jason's question, you mentioned empathy in regards to adults with developmental disabilities. And when I hear that, it can mean one of two things. First, obviously, the good one, and like knowing where people are coming from. But I do want to ask about the second potential meaning, just to clarify. It sometimes can mean that that people don't necessarily believe that adults can be competitive. So I just, do you believe that an adult with, and to just build on Jason's question, do you believe an adult with developmental disabilities can be an attorney and be a judge?
Absolutely. And I just want to clarify, and I don't need to be patronizing whatsoever, but just to make sure I'm clear.
Right.
When I say empathy, I do not mean sympathy. So for me, and maybe I'm misusing the word, and definitely educate me if I am.
You're fine. I was just parsing it.
Is to me, empathy is having the wherewithal, the humility of knowing that there's information that you don't know, experiences, if you haven't experienced it yourself, that there's so much to learn, that there's a perspective that carries with it a wealth of knowledge and information. So certainly there's a huge difference for me with those two terms, empathy and sympathy. I'm not saying one is more worthy of the other, but there's a distinction.
Go ahead, Ben.
As a judge, what have you done to reach out to communities that are more deeply affected by law enforcement?
Right.
crime?
Well, as a judge, I can't say that I have been proactive in reaching out to these communities. What I can say is that number one, I definitely hope to, once I kind of gain a foothold in this job that it's pretty recent for me. And second of all, I absolutely see a critical need for judges to do just that. I don't know if historically, and this is not a critique on any judges in particular, or certainly not the King County Superior Court bench, but I just think historically, nationally, judges have not prioritized the involvement of the community. I think we absolutely should for two reasons. First of all, to learn what the community needs from us, because we are public servants, and I think sometimes people forget that. And number two, to provide information to communities about what we're doing, what we've prioritized, so they can better assess where their taxpayers' money are going, how involved they need to be, because they need to know what's happening behind those doors.
Thank you.
I wish I could talk more about that.
So you are currently on a rotation in the family, the Unified Family Court.
I am.
Do you have interest in experiencing other courts? And if so, which ones?
Absolutely. I've had the opportunity of working with almost every area of Superior Court, not as a judge, obviously, but as a public defender. So as a public defender, I represented adults charged with felonies. I represented adults charged with misdemeanors in Seattle Municipal Court, in district court. I worked with juveniles for, I would say, a total of 3.5 years. I also worked in the area of dependencies when Child Protective Services becomes involved. I worked in the involuntary treatment court when adults and teenagers are psychiatrically committed. I also represented adults who were facing petitions under the Sexually Violent Predators Act. And so now with my my 4.5 month stint in the civil, having a civil caseload as a judge, and now Unified Family Court, I think I've worked in every area of the Superior Court. I think that every single area is valuable. I really enjoy working with juveniles. I have a very strong interest in individuals struggling with mental health issues, including addiction. Certainly the criminal law has been a very strong interest in those.
Great, thank you. And now we're ready for a 30-second wrap-up.
All right. Well, thank you so much for giving me this opportunity. I know that this is volunteer time on very, very busy schedules, and so I really appreciate meeting with you and giving you an opportunity, or being able to share some of my thoughts and positions on issues. I have taken very seriously my role as a public defender for almost 16 years, and I take my role as a judge very seriously as a community servant, as a public servant. So with that said, I would be very honored to receive your support.
Thank you.